So Univision issued a copyright claim against one of my vlogs where I was breaking down the expert testimony in the context of the impeachment inquiry hearings. Oh, I've disputed their copyright claim.
And I won.
Viva Frei, Montreal litigator turned YouTuber, and this vlog is going to be dealing with copyright claims, and how to contest them on YouTube. Incidentally, just to toot my own horn, this is not the first time I have successfully contested a copyright claim on YouTube, but I'll get there. Copyright, what is it? First things first, this is not going to be an exhaustive thesis on copyright law. It is for entertainment purposes only. Maybe you'll get something out of it, but you will certainly be able to navigate social media platforms a little bit better. Copyright is exactly what it sounds like, the right to copy. It applies to all original works. It requires no other formalities. It just exists when someone creates an original work. If you create an original work, it is protected by copyright as a pure matter of fact and law. An original work can be literary, it can be a video, it can be music, it can be a painting, it can be a work of art, it can be any original creation. And once you have created that original creation, nobody else can copy or reproduce that creation without your express authorization. Now, first major caveat is that copyright can be signed away by contract. The copyright that exists over something that someone created in the context of their employment typically belongs to the employer. The employee, being bound by contract to their employer, having been remunerated for the work that they are doing, they don't get to own the copyright over that which they create in the context of their employment. It gets more complicated in the context of independent contractors, but this is why you need to see a lawyer for any specific question. All that to say is that while an individual typically benefits from copyright over things that they create, there are situations in which they don't own the copyright over that which they create. And copyright doesn't just apply to the original form of that particular work. If you write a book, for example, sure, nobody can photocopy the book and resell it. But third parties are not allowed transforming your written book into an audiobook and then claiming that they own the copyright over that audiobook because it's not a physical book anymore. Copyright protection is the protection from unauthorized copying or reproduction of the original work in any form whatsoever. And in law, there are a great many recourse for copyright infringement. The owner of the copyright can actually seize all of the reproductions of the copyrighted work. They can seize all reproductions as though they are their own because they were in fact reproduced without the authorization of the copyright holder and therefore are the property of the copyright holder. In most jurisdictions, they also allow for statutory damages, meaning that the copyright holder doesn't actually have to prove any actual damages. They can sue for statutory damages provided for in the law without having to show any damages whatsoever. And an interesting anecdote from my practice of law, we once sued a restaurant because they basically copied everything about my client's restaurant right up to the menu itself. And when I say copied, I mean copied. They literally just changed one letter in the restaurant name, and they literally copied our menu. I think they actually just downloaded it off the internet. It was a direct reproduction of our menu, save and except for the restaurant name, but there were still typos in their stolen menu that had our original restaurant name in their menu. We sued. We took a provisional and interlocutory injunction. We sued for statutory damages. We even seized all of their assets that were reproductions of our original copyrighted material. Although we had absolutely no use for it, we seized their menus, we seized their menu cards, we even seized their awning with their restaurant name on it because it was exactly our restaurant's name, save and except for one letter. And what typically happens in these situations, the restaurant went bust, the restaurant was judgment-proof, the principals went bust, they were judgment-proof, we ended up with a great judgment on paper, but no one and no thing to execute against. Like I say in law, sometimes even when you win, you still lose. But for the purposes of this video, I suspect most people are going to be more interested in copyright as it applies to YouTube and online stuff. When it comes to the internet, people tend to think that because they can find it online, somehow it is not protected by copyright, but that couldn't be further from the truth. It's not because you can find an image by Googling it that there is no copyright protecting that image and that you are free to use that image as you so choose. And people always get in trouble for this on YouTube as a platform. They use images that they've pulled online without really appreciating that they are protected by copyright. They think they are free to use them if they give attribution or credit, and they use them in their own videos, which they monetize. And sure as sugar, when the copyright holder finds out that a third party is making money off of their original work without their authorization, the proverbial poo-poo hits the fan. It is not because you can pull something from the internet that it is not protected by copyright, and you are not free to do so with impunity. And when the proverbial poo-poo hits the fan, we always hear the same excuses: fair use, fair use, fair use. What is fair use? Fair use is the most common and almost reflexive defense, and it is oftentimes improperly used and or outright abused. Fair use is not a standalone defense that prevents someone from getting sued. It is an affirmative defense that one raises before the court, and it does not exist as a legitimate defense until a judge recognizes fair use as a bona fide valid defense. Someone who is infringing on someone else's copyright cannot say, "You can't sue me, it's fair use." Wrong. They can sue you. You have to raise as a defense that it is in fact fair use, convince a judge that it was, in order to have your defense recognized by the courts and not be held liable for your copyright infringement. And fair use as a concept itself is oftentimes misunderstood. Fair use as a say concept is pretty straightforward, but it is fairly nuanced. Examples of fair use are using something for parody or commentary. It involves using copyrighted work for educational purposes. Fair use covers transformative work of the original work into something new. But even in the context of fair use, there are certain factors that a court will take into consideration in determining whether or not the use is in fact fair use. Those factors typically involve how much of the original work was used. When it comes to commentary, people sometimes think they can run the entire original work to the extent that they are commenting on it. But if you reproduce the entire original work even for the purposes of commentary, it will not be deemed to be fair use. Generally speaking, one has to use as little as possible of the original work in order to make their point. If they end up using more of the original work than they have to in order to make that point, it may no longer be fair use, it may just be copyright infringement. Another one of the factors that judges tend to consider that is closely related to the amount of the original work used is whether or not the fair use detracts or increases traffic to the original source. Generally speaking, it works in favor of the defense of fair use to say, look, my use of the original work is actually directing more traffic to the original source. Through my fair use, I am not directing traffic away from the original source, I am directing interest towards it. The portions that I have used for the purposes of my commentary, critique, or parody are actually going to drive more people to go view the original, as opposed to, say, simply reproducing the entire original work in my commentary, and then people no longer need to go watch the original. The criteria of the transformative nature of the use is also something that is determined on a case-by-case basis. If the fair use has genuinely transformed the original work into something entirely different, then it will be deemed to be fair use. If the fair use only increases or decreases the audio or turns the video into a black and white video, that will not be sufficiently transformative to constitute fair use. And so every time somebody plays this transformative game argument, they are playing with fire because it has to be sufficiently transformative from the original work in order to qualify as fair use. Now, when it comes to music and video, there are a number of misconceptions out there that if I use less than a certain amount of seconds, it qualifies as fair use by definition. There is no safe amount to use of any original copyrighted work. Someone can use a 3-second video clip, one verse from a bar, and it can nonetheless constitute copyright infringement. So while there is no hard and fast rule about how little someone can use for it to qualify as fair use by definition, typically using the least amount possible is the best defense. Which is why every time I make a video and I use a clip from a movie, regardless of how short that clip is, I do know and recognize that I am playing with fire to some extent. The copyright owner of that 3-second clip can claim my video for copyright infringement, and even if I have the best defense in law for fair use, I still have to make that defense in front of a judge. And so that is the 30,000-foot overview, the 101 of copyright law. Let's bring this back to Univision trying to make a copyright claim on one of my videos where all I was doing was breaking down the expert testimony in the context of the impeachment inquiry hearings. Univision, for anybody who doesn't know, and I'm reading from Wikipedia, is an American Spanish language free-to-air television network that is owned by Univision Communications. It is the country's largest provider of Spanish language content, followed by American competitor Telemundo. I get an email from YouTube to the effect that someone has made a copyright claim against one of my videos. Don't worry, I'm not in trouble, they are just claiming the video and all the monetization that derives therefrom. But I'm not in trouble. I just don't get to make money on my video anymore. They get to make money on my video. Univision, the largest provider of Spanish content, is taking my money from my video where I was breaking down the deposition hearings. When I got the email, I first checked who was making the claim and what part of the video they were claiming. And I was especially surprised to see that the portion of the video that they were claiming was the part of the video where I was reproducing Representative Matt Gaetz' line of questioning.
No personal knowledge of a single fact, and you know what? That continues on the tradition that we saw from Adam Schiff, where Ambassador Taylor could not identify an impeachable offense. Mr. Kent never met with the president. Fiona Hill never heard the president reference anything regarding military aid. Mr. Hale was unaware of any nefarious activity with aid. Colonel Vindman even rejected the new Democrat talking point that bribery was invoked here.
Matt Gaetz is a U.S. representative asking questions in the context of public impeachment inquiry hearings. How on earth can anyone, including Univision, claim copyright over that? You know what the answer is?
They can't.
Above and beyond all of the affirmative defenses of fair use, you know what the best defense to copyright infringement is?
It's public domain and not susceptible of copyright.
And this is not the first time that a media agency has issued a copyright claim against one of my videos for what is patently already public domain material. A while back, Warner Brothers issued a copyright claim against one of my videos, the one where I was breaking down Lil Wayne's deposition. And I disputed that claim on the basis that the video of the deposition, regardless of who pulled it from the court record, is a public court document. I don't care if Warner Brothers or TMZ are the ones who found the video of the deposition. I don't care if they find the video and then add their watermark to it as though they somehow own it. One cannot own that which is part of the public domain. In a way, it's not any different than spray painting your name on a public wall and saying, I now own this wall because I spray painted my name on it. So I disputed Warner Brothers' claim on my video on the basis that the deposition itself is public record and they cannot claim ownership over it. And they abandoned their copyright claim on that video. This time around, I file a dispute on the exact same basis. The impeachment inquiry hearings are public hearings. Imagine a media organization claiming ownership over these public hearings. It's actually even more insidious than Univision trying to claim monetization of my use of that public material. If they purport to own the copyright to it, not only can they claim monetization of it, but they can make me take it down off YouTube. They can claim the monetization from the video, they can give me a strike for having used it, and they can force me to take down the material. Copyright holders have various recourses when it comes to copyright infringement. They don't have to claim monetization of that use. They can act spitefully and say, no, take it down and here's a copy strike. So imagine a world in which media agencies own the rights to public hearings. Now it's a question of a media agency claiming ownership over public hearings and potentially removing them from the internet if they don't want people to see them. This is the real issue and warning that I made known at the time of the EUCD.
That should not be the concern for the people. The concern for the people should be how this new provision of law is going to be used to control the dissemination of information. I mean, let's just contemplate a hypothetical. A sex tape involving a celebrity. Okay, no, forget that. We'll actually use an example that could otherwise be found on YouTube. A video of a prominent politician abusing their dog. What would otherwise be fair journalistic reporting, commentary, etc., can now be circumvented by, let's just say, the politician buying the rights to that video and then claiming it and taking it down once it's uploaded to YouTube. Imagine that. That, as far as I'm concerned, is where the real concern should be coming in for everybody.
The risk is not one of making memes illegal. The risk is of copyright abuse and removing from the internet newsworthy items or material that is nonetheless part of the public domain. Imagine a news agency claiming copyright over congressional hearings and limiting the manner in which those can be made public. That is the true risk. I disputed Univision's claim on the basis that the object that they were claiming copyright over is part of the public domain and therefore not susceptible of copyright protection. And they released their claim.
Yes! Yes! Oh, yeah! Can you feel that, buddy? Huh? Huh? Huh?
One small step for me, one giant leap that nobody's going to care about tomorrow. So that is that. When it comes to copyright, fair use is one of the defenses, but fair use is an affirmative defense. Being part of the public domain is an absolute defense. And while there is not yet a method on YouTube to sanction abusive copyright claims, at the very least there is a method to contest them, and now you know how to do it. You can always try to raise the fair use defense and hope the copyright holders, out of the goodness of their own heart, are going to recognize that defense. But nobody can argue with that which is in the public domain, and nobody, absolutely nobody, should be claiming ownership over that which is in the public domain. If you like my content, you like my videos, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. All support links are in the pinned comment, and now you know your vlog. Peace out. Booyah!